Good morning, friends. Welcome back to my lecture. This is the third lecture on law and economics. In this lecture, we are trying to actually elaborate a little bit on what we left in the lecture, the second lecture. That is, it's on the second lecture was on the tools and concepts, but today what we are going to do is actually to see that whether within that tools we were given priority to the efficiency analysis, and if efficiency analysis is the single most important analysis, then that analysis is actually good enough or fair enough to adopt for understanding the legal doctrines as well as the legal aspect in economic perspective. So this is actually the lecture which is in fact a critique to what is efficiency as a tool in economic analysis of law. So with this introduction, it's also important that as a first part of this lecture, we need to look at the strength of efficiency, because we have already know that in the law, efficiency perspective, the different kinds of efficiency, and then obviously efficiency is a relative term in that context, because the absolute efficiency is the Paretian efficiency, which is what we call the first best solution. The first best solution is first best because every given situation, as I pointed in the earlier lecture, that every given situation is an efficient situation, because there is also a problem with the interpersonal comparison, intertemporal comparison, etc. So if that is the case, because when we speak about a pie, we strictly speak about that pie. There is nothing comes from outside to increase the pie. I mean, then the whole assumption and premise is changed. So we don't actually consider such kind of such kind of intervention in the understanding of economics. So every given situation we can analyze with Pareto efficiency, and that efficiency can tell us that whether the pie is being distributed properly among the players or the people who are engaged in that set. So if that is the case, every given situation is an efficient situation, because no matter who gets what, the only concern under the efficiency is that whether that has been distributed 100% or not. Whether one person get 99% or one person get 1%, that doesn't matter. So this is actually leave out the question that whether the distributive question is important in the efficiency analysis, because when we speak about efficiency, we don't worry about distributive justice in that sense. This is about the note which we left in the earlier lecture, that is the second lecture, and this is the same portion we will be strengthening in this lecture, because it is very important and necessary to clear what we are standing for and what we can apply in the legal analysis or the analysis of law in that context. Again, we have already seen in the earlier lecture that there is another kind of criteria which is called the Calder-Hicks criteria, where you call it as actually not the first best, but every movement from state A to B is always comes with a losing end on the other. So in that sense, it is more realistic, because if we have a given situation, that given situation cannot be alterable, and any change in the premises is actually incomparable with that the earlier. In that context, it is pretty difficult to actually rationalize the movement from one stage to another, or when we argue the whole intention and the whole objective of economics is actually to understand development or growth or production, increase in productivity, production, etc. So all these aspects are basically inherently contradicts with the kind of first best application, because first best is actually something which you normally do with the static nature of the premise. So if that is the case, then when the situation is situation is actually situation is changes over the period, then things are not going to be as lucrative or as nice as we think. So in that context, this is the first best question, the first best solutions importance, as well as the relevance as a tool to understand the difference or changes in the society is always been questioned. In that context itself, only Calder and Hicks had come up with the idea that if you have actually a movement from state A to B, and then you have to look into the social optimality or the social benefit, and the social benefit means some people may get loosened or worse off. Then that worse off situation should be evaluated with that of the gained situation, and the gained situation is better, and gained situation is far better than the loosened situation. Then it is also advisable to go for that kind of change in the society, because ultimately the society get benefited out of it. So this is what was actually called the Calder-Hicks criteria, and these two things in fact makes the building blocks of any kind of economic analysis in that context. So one is in a static format and the other one is on a dynamic front. So now the question is that, is efficiency a good goal of law, good goal for law? Well, because this question is very important, because normally the lawyers never accept that this has anything to do with the efficiency kind of thing. But in the law and economics venture, things are actually done different, because of many intervention from the part of economists in the field of teaching, as well as researching in the field of law and economics in that sense. So, however, the question still remains as intact, because the efficiency, as we said, that it's only talk about the efficiency of the distribution, that is whether the pie is being distributed 100% or not. So in the law also this question comes up with the clarification required, that whether the law is again can consider in this format or something else. Like in the fairness argument, people try to say that efficiency is not fair and fair is not efficient. So you have a very different view. We will discuss that in a subsequent point. But this question is very relevant, but as at the same time it's also perfectly rationalizable in some point, and we will see that what are the strength of this particular understanding. That is, there are at least three reasons why that is the question we ask. First one is that while economic efficiency is not the only thing that matters to human being, it is something that matters quite a lot to most human beings. The second reason is that there is evidence that considerable part of the legal system we live in can be explained as tool to generate efficient outcome. It is a lot easier to make sense out of the tool if you know what it is designed to do. A final reason is that figuring out what tools lead to efficient outcome is one of the things economists know how to do. And when you have hammer, everything looks like nail. This is a very interesting way of looking at the problem. This is a nice observation from the book, Friedman's book Law's Order. So this answers the question that why is it interesting to study efficiency, not the question should the law be designed with the goal of achieving efficiency. Both are different questions. The first question is that why is it interesting to study efficiency? need to be answered first, because you see, earlier people try to make a point that the fairness aspect is but the point is that what does actually make something fairer? Okay, and suppose if you have 100 rupees, point economists always have whether you are spending that 100 rupees or you are keeping 80 rupees and you distribute 40, but still 20 rupees is left with you, but you don't talk about that. So you say that it is fairer that we have 40, so it's fairer. But is it fair really? So 100% of the money is being distributed, not as again a question which somebody has to shoot out. So this is what is actually the concern, but we will be clarifying the same with more rigorous understanding. Let us come to the point. So what we think is in the Richard Posner's paper, that is the ethical and political basis of efficiency, norm and common adjudication, things are seen in differently. Let us actually, as a strengthening point, we start with the observation that if you buy a lottery ticket and don't win anything, you can't complain, right? So what we are trying to say is that through this example, if I am buying a ticket, if I don't get anything, even the probability is remote or a higher one, I don't complain. Why? Because I am internalizing it. Imagine before we all start driving, everyone in the world got together and negotiated a liability rule for traffic accident. Okay. Similar is the case with he's saying that okay, before we drive, we negotiate for a law which is in fact liability rule. Now, if one rule is more efficient than another, we will all vote for that rule ex ante. So before we begin with the kind of situation or the kind of the rule or the incident, what we do is actually we agree upon certain rules a priori. So this is in fact resounds the same thing like what Adam Smith trying to make in the theory of moral sentiments, where he was actually wrote his piece of Wealth of a Nation later, and the moral sentiments preceded the Wealth of a Nation. What does it mean? See, unless and until we have as an individual human being sentiments, human being should have sentiments of different kind. If we don't actually really talk about that sentiments, you can't have any sort of trade or impartial maximization or whatever. So even the maximization comes from the sentiments which you talked earlier. Similar to this, what only he Postal tried to make, that is, if suppose if we want to drive, that is an activity, an economic activity. If we want to conduct or undergoes any kind of such an activity, so a priori to that you should have some sort of mechanism which resolves if there is a problem. So this is trying to make a point that a legal system is actually a priori to the action. So liability rule or negligence rule is already existing while you drive, or if you drive something happens, then people say that either there is a liability or no liability, or negligence rule is in place. So you have to go according to it. So we don't actually negotiate any law during the incident, but before that incident, the same has may be existing, or it would be actually seen like that. So if that is the case, then what we are trying to make through this particular statement in the paper, he is trying to say that it is always good to have an efficient rule which is a priori accepted. So this is not new as far as the proposal is concerned. As an example, Suppose there are two candidates rules for accident liability. That is, you may be having two candidate rules for liability or accident liability. One favors pedestrian, one favors driver. Okay. So the one favoring car driver is more efficient. That is what is actually he is trying to propose. How we comply with this sort of statement? Suppose let us discuss the matter with a detailed note. Suppose the strict liability says that if you hit a person, then 100 rupee worth of loss you may incur. So expected pay of a pedestrian is 0, strict liability. Expected pay of the injurer is actually 100. So expected payoff, if you don't know which one you will be in, so what is actually your probability? -5. If somebody I may get, I may not get, because I don't know the rule. Alright. Suppose if it is negligence, expected payoff of a driver is actually the negligence amount. If he is actually non-negligent, that is if he or she took a due care, say for -20, that is any cost, additional cost you incur much before the accident or the incident takes place. So you had a kind of precautionary expenditure. So that precautionary expenditure or due care is there. So that cost is -20. So whether the accident happens or not, you have to incur that. That's what it is actually, a gross -20. So what would be the expected pay of a pedestrian? So expected pay of a pedestrian is actually -60. That is if the person hits, if I am negligent, then I have to actually bear the cost. Alright, because I don't know which. So I will also take a kind of pay, it's care level, because otherwise I'll lose my limb or whatever. So my expectation is actually a higher one. So expected payoff, if you don't know which rule is existing, then what is actually the kind of amount is maybe 40. That is 1/2. That is if I say that, okay, which rule is expecting, then the total of 2%, that is 20 plus 60 is 80, and then the probability is 1/2, because only two individuals exist. In that sense it is 40. So my probability of losing is 40 vis-a-vis the probability of 50 strict liability rule. So which one is actually preferable for these people? So if they are ready to minimize their cost, then a probability of 40 is less than probability of 50. So in that context, what people try to say is that negligence rule is better than strict liability. And in the normal case, this has been, we will discuss the same thing in the tort case and tort case while we discuss about the tortious or accident liabilities, etc. So Postner's point is very precise, that he is saying, trying to make this, before we know who we will be, everyone would unanimously agree to the second rule. Why? Because the probability of the money which you lose is less in that later case and the former. So again, if there is a, of course there are questions to this, and I'll reserve that for later. And let us see another example, that is the landlord friendly versus a tenant friendly law. So might think tenant would prefer pro-tenant laws, but rents are determined competitively. Now let us actually see carefully, that is landlord friendly versus tenant friendly law. So you have actually two people, one is a landlord, the other one is a tenant. Now two laws, just like the binary law which we have seen in earlier case, that is First law is supporting the landlord, and the second one is supporting largely the tenant. Now, might think tenant would prefer pro-tenant law. Now, it is natural that if I am a tenant, I would like to have a pro-tenant law. If I am a landlord, I am having a likelihood of liking the pro-landlord law. So, but rents are determined competitively. That is actually a kind of a situation. Competitive rent setting is, I don't know, because if tenant and competitiveness here, I mean, maybe personal means that the both party can actually go and negotiate and determine, or the market is already fixed. But in the perfect competition, we have seen that competitive price setting means a price is a priori set in a pure sense. If it is a market sense, then if it is only imperfect market, we need to go and talk. Otherwise, the price has already been set because price is given there. Whereas in the competitive, that is imperfect competitive case, only the people go and talk or negotiate their price, because in the perfect competition that is not necessary, because everybody know that what is the cost involved to the other person, and everybody know that what is actually if somebody comes and buy the commodity which you offer. So if that is the case, then both of you know that what is your reservation price of buying it and selling it, then that itself indicate that price is being already set. This is what is called a perfect competitive price. Differing to that, and imperfect competitive price is completely different, where you may not be knowing that much, that is what is the reservation price, etc. If that is the case, then you negotiate, and that will determine the price. Now in this case, it is a little tipsy or kind of confusing, that this assumption that is determined competitive. But anyway, let's take it as rent is given, the perfect competition example. So competitively determined, so nobody can influence it. So if law becomes more tenant friendly, rent might go up to compensate. So if laws become more tenant friendly, then what is the case is actually in this context is person trying to make is rent might go up, because so this is actually the imperfect competition pricing. So that is why the second assumption is about the imperfect competition. So it is competitive means actually one, it is not in the pure sense that one nobody can influence, but one can reciprocate what is the other strategy or what is others behavior given the existing rule. So in that context only this makes a difference. That is, if law becomes more tenant friendly, rent might go up to compensate, and if tenant friendly law is less efficient, it could make both sides worse off. So this is a statement. So suppose tenant get $1,000 value from apartment minus rent. Okay, landlord pay 100 for heat and 600 in other cost. Without this law, tenant would pay for their own heat, so they would heat apartment less and they get 980 value and pay 60 for heat. So my think tenant would prefer inefficient tenant friendly law, but rents are set competitively would go up to compensate. So both landlord and the tenant to do better under the old law. So this is what is actually they are trying to make. But of course this is not a perfect example, which as I said, because if you say the competitively said that the one person is actually having a higher monopoly, because that is why you say that okay, if you if the laws are tenant friendly, then who is having, in this case the tenants, rather than the tenant, the landlord has more power to control the price of the commodity. So there is a kind of monopoly or a quasi monopoly or whatever it is. There is a market power which is biased towards the landlord. That is why they can actually increase the price, otherwise they cannot increase. In the perfect competitive setting, this is not going to happen. However, this is actually the real world analysis, and indeed this is having its own take. So landlord pays for heat. So we have a payoff matrix, that is tenant's payoff is 1000 minus rent, and landlord's payoff is rent minus 600 plus minus 100. So tenant pays for heat, then 980 minus 60 minus rent, and the landlord's payoff is actually rent minus 600. So tenant and the landlord, in that sense, the tenant's payoff of a heat is 980 minus 60 minus 760, which is equal to 160, whereas the landlord is actually 760 minus 600 is 160. So tenants in the landlord pay for heat low, where 1000 minus 850 is equal to 150, whereas in the landlord's case it is 850 minus 600 minus 100 is 150. So in that sense, who is going to benefit? And the tenants pay for heat is actually gives more profitability to both parties, that is both the tenant and the landlord indeed get benefit out of it. So this is actually trying to make a point that a priori to the business, they had actually a rule which is friendlier towards the landlord, which is actually what is efficient, makes efficiency. So we know that there are certain rules which indeed gives a priori understanding that what is beneficial and what is not. So in that context, efficiencies here play a very crucial role as far as Posnerian understanding is concerned, because he is trying to make a point that, see, the overall pie is very important. That is, the distribution of pie is very important, or the size of the pie is very important than anything else. So limitation of the Posnerian efficiency in that context is follows. The problem that Posner's basic argument is, if we choose the most efficient legal system, everyone is compensated ex ante for the choice and should willingly accept the outcome they get. So this is the example which he started saying, that is, if you buy a lottery ticket, you don't, even if you lose, you don't complain. See, that means that a priori to the decision, which is buying a lottery, your compensation is already made. If you get a lottery ticket price, then that is what is called a win-win bonus. Okay, because otherwise you never complain. So the lottery ticket analogy requires risk neutrality. On the contrary, so 50% chance of 1 million is just as good as 50% chance of 0.9 million, and 50% chance that 1 lakh, if 1 lakh is worth more to you when you are broke and than when you already have 9 million. This argument doesn't work in that context. So a counter Posner is actually made by Hammond in 1982. Efficiency is really a special case of utilitarianism and is subject to the same limitation of utilitarianism. This is fundamentally posed by Hammond in 1982 article, where he was said that the efficiency itself is resonates with the concept called utilitarianism. That is, value is equal to willingness to pay. So you say that some commodity's value is exactly equal to the willingness to pay for the commodity. Is it so? So the value of the commodity is willing. So what you are talking about is exchange value of willingness to pay, is actually called the exchange value. So value of the commodity is equal to the exchange value of the commodity. Is it so? So $1 worth the same to everyone. The question is that is $1 worth the same person? If that is the case, things are nice, right, in the real world. So these are fundamentally asked by many people when we go for the efficiency argument. Equimarginal utility and other things stuff. Okay, that is $1 is equal to equal to everyone. So what is the alternative in that context? If you criticize and say that efficiency is not good enough or fair enough to have understand or accept as a tool, then what is the alternate? So recall that efficiency equates utility, or how much society want you to have something with your willingness to pay for it. Efficiency is in fact not equity. Efficiency is not in fact fairness. Efficiency is not in fact justice. So when we speak about legality, all these things comes in the foray. That is, you talk about equity, you talk about fairness, you talk about justice. So is the question is that is all this one and the same in that context only, as I pointed in the earlier lecture, that the Posner made a point that efficiency is justice. So efficiency is fairness kind of proposal he has made. So let us look into it. But many people won't agree that efficiency is equity. So efficiency is only about how much wealth exists, for example. That is quite clear. So when I speak about the pie, I am telling that the efficient, or I made a point that if that is efficiency is our concern, then what we are trying to make is actually the distribution of the pie. That is whether the pie is being given to everyone or in the set complete, or the pie is being exhausted by the players. That is the only concern of the efficiency. But at the same time, equity is something to do with who is getting what much. So efficiency is only about how much wealth exists, not how it is being divided up. Laws favoring business over consumers or rich over poor may be efficient, but still may not be socially desirable. For example, these days people try to say that many people, the wealth of the nations increased tremendously over the last 100 or 200 years. In the Farewell to Arms book of Gregory Clark, he tried to make a point that the world income had many-fold increased over the last two centuries. That is, from 1800s to 2000, there is a tremendous increase in the wealth of the nations, or the per capita income of the world in that sense. So money being already, but at the same time you also remember that number of people getting poor in this larger money making process, or when the world becomes richer, is also increasing very rapidly. So that is actually the kind of problem which people try to do. So if it is efficient, then it is not necessarily equitable. So this is the question which people try to argue. So efficiency is not fairness indeed. So now the question again echo about fairness. So for one thing, efficiency considered only outcome, not the process. And what is a fairness? Fairness is not to do with the outcome. It is something to do with the process. So if I would say that most of the time people say that my action is not fairer, or X action is not fairer, or Y's action is not fairer, or at the same time some say that X action is fair and Y's action is not fair. So all kinds of this is actually comes from our own day-to-day exercise of efficiency, fairness, etc. So in that context, it is quite clear that fairness is something to do with the process. So who has how much matters, but not whether they got it by working hard, or by being lucky, or by having light colored skin, etc. Because this is an important question that people used to ask: why you become a in economics normally we take things as granted, like you say that the entitlement is given. So the question is that how you have that entitlement, or how it is going to be given. For example, there are many societies. If we study society, we say that every individual is one and the same. But the question is that so? So the real world questions are much more, complicated. That is, in front of market, every individual, buyers and sellers are one and the same. There is no distinction. There is no gender disparity. There is no color disparity. There is no caste creed disparity in front of market. That is, if you are a buyer, you are just a buyer. Whether you are whether you are a male or female or she-male or he-male or some, whatever your gender doesn't matter. You are a buyer. But in the real world, things are not actually reflective that kind. Similarly, if people say that okay, I am educated because I am hardworking, it doesn't mean that the other person is not educated because they are not hardworking. Similarly, we used to talk about hard works and all. So many of us hard work. So the point is that some people work, for example, a agriculturist or a farmer who get up in the morning 6 or 4 or 5 in the morning, and they will go till 6 in the evening in their field. But what do you think that their productivity is much lesser than us? But their pay is very less. So what are they not hardworking in that sense? Can we say simply like that? So there are so many questions people do ask about fairness and the efficiency in that sense. So it is not that easy to basically say that efficiency is fair. So or fairness is exactly so. Efficiency is in that sense is that's what we said. It is talks about the outcome, not the process. But fairness is something to do with the process, not necessarily the outcome. Who has how much matters, but because why I am educated, because maybe my parents support, or if there is no parent to be supported, then I may not be able to study. So there are so many things in that sense. So, or not necessarily a parent, somebody has to. So otherwise, how could I go to schools in that sense? So if the state is not supporting, how in the countries like whatever, and have a better education in the Scandinavia. So the point is that things are not taken for granted. All this process matters. So law might be efficient, but violate our intuitive notions of right and wrong in that context. Example from before, that is might be efficient for government to seize your car and give it to me, but this might strike you as a wrong or unfair thing. So if I have many cars and somebody can confiscate, do you think that that is fair to you in that sense? So you may say that that is unfair. So another example is this class is full of several people on waiting list. Efficiency, whoever is willing to pay most for a sport in the class values it the most should get it. How about I auction off the last few seats in the class and keep the money? So all this, you may not be accepting all that. So this is what in fact real world things happens. So lead to efficient allocation, the right people end up in the class, then you all start to question it. So but probably not a rule we want to encourage. Now let us talk about a Pole Town neighborhood council with city of Detroit early 80s case. And this will be discussed in the coming lecture of tort law, where you will see that whether that is efficient or not, or fair or not. What is actually the basis of all this argument. So we will see all this is in the subsequent lectures on different aspect of tortious law, contract law, and property law, and criminal law. So efficiency is not maximizing happiness in that sense. By equating value with willingness to pay, efficiency ignore the possibility an increment dollar might mean more to someone poor, and it ignores the possibility of really wanting something but not being able to afford it. Example, suppose I need a heart transplant but could only pay $5,000 for a heart, and some rich guy thinks it would be cool to have a human heart in a box and is willing to pay $1 million. So a creepy example from Posner's economic analysis. So this is also very important. Like If somebody, if you subscribe the idea called someone who value the most has to get the commodity, then a person who is having a $1 million should get a heart in his box than the person who is in need, because according to our own analysis, if we value the most, then that they have to get it. So if that is the case, then you feel nothing wrong in a rich guy getting a heart in his box than a person who is really in need. But so all this is in fact makes a lot of questions. A part of the problem here is distinction between willingness to pay for something you don't have and willingness to accept an offer to sell something you already have. Efficiency doesn't really distinguish between these two ways of valuing something. When they are not equal, it's hard to make sense of things. So that is why when we speak about value, we should be very careful about value. Value doesn't mean that the value of exchange only. Value has a different meaning and different connotation, and there are different kinds of value. For example, intrinsic value, real value. Then you have exchange value, what we try to say. So all this is not going to be one and the same in that sense. So this is the point which we have to keep in. So as an alternative, therefore people try to argue that the fairness, equity, justice, etc. are not bad enough, or you cannot simply discount the very existence of all that norms or tools to evaluate the legal analysis. At the same time, what we have to keep in mind is that efficiency is also should not be discounted, because that there are certain bright side for efficiency when we go for a decision making. So because you, as we said, it is actually the outcome, that is at the end of the day people look at whether your money is being spent or not, whether your pie is being exhausted or not. So that is also very important as far as the thing. So one is not complete substitute for the other, but it coexists. That is the point which we have to keep in mind. So therefore, we don't say that fairness is bad or equity is bad, only efficiency is good. No, we don't actually make such a point. But what we do is actually efficiency has some edge, and we will see that what is actually the edge. So in Cooter and Nullen, for example, efficiency, they were arguing actually in a very different way, that is, efficiency should not be necessarily be the goal of society. So what is actually they are trying to say is that society is not actually something which is so much concerned about the exhaustion of the thing. So complete exhaustion of the things. What is actually they are trying to say is efficiency should be the goal of a legal system. I do have a problem with this statement, but anyway, as a standard understanding of the time, let us actually go for it. And if redistribution is desirable, it's better to make the legal system efficient and address distribution through tax. Now we say that okay, let us have an efficient legal system. Now how do we make an efficient legal system is again a question, and it is a process. And it is not that easy as we think that okay, every law is, then there is no possibility of having a new law, because every law is already been accepted and voted, and then why should somebody amends? We will see this difference as far as the efficiency's perspective is concerned again, because most of the time, for example, most of the time people argue that strict liability is better than negligence rule in some point. And in some point, people again argue that negligence rules are better than strict liability rules or liability rules. Again, people keep changing this version of strict liabilities, or preference over strict liability over negligence rule, and negligence rule over strict liability rule. So why this happens if one is actually better than the other? So it is also important to see that which side we are actually trying to part with, or which side you are really in. That is also a matter of concern. So historically, the interest of that thing always changes, whether you like a product liability or a negligence rule in that sense. So we will see all this differences in the coming lectures. So, in a nutshell, Cotter-Newland offers four reasons why the tax system is better way to distribute wealth than the legal system. This you may refer from the text. So, what in a nutshell we want to argue is that we have seen two arguments in favor, that is Posner. It is that it is what we all would have agree on ex ante, and if you want to redistribute, it is better to do it through taxes. So thus there are definitely some problem with efficiency, that is the distribution matters, but everything is monetizable, but everything is not monetizable, and people might care about procedural fairness and equity aspects. So, however, as I said earlier, my take in this class is we will mostly focus on positive questions, but in the background, I think of efficiency is a pretty good, but definitely imperfect measure of goodness. This imperfection reflects due to the fact that the distribution entitlement is given, but the concern of fairness or equity matters when we do consider things in the light of a varied distribution, which become a matter of policy formulation. As I said, in the efficiency concern, efficiency as a tool, it is at the end of the day it is important, but it is not completely substitute the other concept. Okay, because as Posner said, efficiency is justice, and justice is efficiency. So all this is actually not necessarily true always, but partly efficiency is important. So that is the take which we have. So as a tool, efficiency is a good goal somebody can set, and they can work for it, but doesn't mean that it is the perfect answer to all the questions. So with this note, let me conclude today's lecture, this part of the lecture, and we will see property right in the next lecture as a starting point of all the law and economic analysis or the economic transaction per se. So thanks once again. Thank you all for your patient listening. Thanks.